Hi, I'm Lauren Lambert. If you're getting this video, it is because you are my client and your case has just recently been set for a hearing. If you're not my client, then this information is some general information regarding what you should be doing when your case is set for a hearing. There is a more detailed video I will be providing you regarding what to do in the hearing, and this more detailed video will be provided approximately a week or two or a few days before the hearing. But now that your case has been set, we need to make sure that your medical records are completely up to date. So if you have had any continuing medical care or you have had an evaluation from a healthcare provider, we need to make sure we have copies of that to provide to the Social Security Administration. It's important that in doing this that we don't provide duplicates and that your records are organized by provider and are in chronological order. The next thing that I like to do as your attorney is I want to interview potential witnesses to come to the hearing on your behalf. Many Social Security attorneys and representatives do not ever have any witnesses come. My opinion is this is a bad idea. I know that I have won cases because I have had witnesses other than my client come to the hearing. Now, on the other hand, you don't want to overdo it. Social Security judges don't get paid any more or any less regardless of how much time they take during a hearing, and they think they know what they want to do or are going to do, and they would rather not listen to any witnesses. However, witnesses are indispensable in certain mental health claims or issues involving mental health, and they are also indispensable for claims involving certain things like chronic fatigue or fibromyalgia or other conditions where the impact upon a person's life isn't readily understood by just the medical records, and witnesses help complete the picture. I know many administrative law judges who have been reluctant or resistant to having witnesses come have been given more helpful information by the witnesses, and while they didn't completely apologize, I've had them tell me that yes, it was very helpful to be able to hear the witnesses and listen to what they had to say in fully understanding the particular claimant's complete disability and the effects that that disability has upon their life. So prior to the hearing, about a week or so prior, I like to meet with between 1 to 6 witnesses who may know you very well, and preferably those are witnesses that would have no reason to be biased in your favor. Now the reality is people that know you very well often have a reason that maybe a judge could point out that biases you or biases them in your favor. The point is we just want to get a good mix of witnesses, maybe a couple friends, a couple family members, a couple of people that worked with you or worked with you in the community who know you fairly well, so they know what your condition is or your conditions are and know how those conditions have affected your ability to function. Once you get those witnesses and start thinking about them, I will be asking that you have them come either all at the same time to my office, or I can meet with them at any place that you would designate. Now, I like to do that all at one time. So I am willing to meet on weekdays, weeknights, weekends, or weekends in the evening, because it's more efficient for me to speak with them all at once. So if you can arrange for that to happen, that is how I would prefer to do it. But if that's not possible, again, I can do so individually or in a couple of groups. So beware that that will need to be done, and we will be working with you further to accomplish that. Thank you.